Good morning, everybody, and welcome to Sunday Fun Day from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Thank you, everyone, for being here. This is our last Sunday Fun Day of August. Can you believe that? It's August 31st, 2025. I cannot believe how quickly August went by. I can't believe how quickly this whole year is going by. And thank you, everyone, for carving out some time to be with us this morning. This is one that you're not going to miss. We are very excited about today's show. A lot of great questions, some announcements that we have for you guys coming up. And spoiler alert, this is our last Sunday Fun Day for a couple of weeks because we're going to be taking next week off, and I'll explain why in a bit, but we are so glad that you caught us here for the last Sunday Fun Day of August. Hello to everybody who's in the chat. We got a bunch of people already. I see, here we go, Chihuahua Mama and Crazy Mom RN and Afton and Best Nancy. Thank you so much for gifting the membership, and Real Happy 33 and Black Witter. So good to see everybody, and a lot of new faces. I see Little Busy Brains. Love that name. Susie 6040. Thank you guys so much. That girl Banks. Thank you guys so much for stopping by. Let me introduce myself to everybody who might be new here. My name is Joshua Ritter. I'm a former prosecutor with the LA District Attorney's Office, and then I left to go into private practice as a criminal defense attorney. This is Courtroom Confidential, where we try our best to present to you both sides of the courtroom. We hope that we do that. And this is Sunday Fun Day, where we answer your questions that you've left us in voice messages throughout the week. And we've got a bunch of good ones this week. But this week, we're going to have a little bit of a shortened show. I'm going to try to get it through as many calls as I can, but we're going to try to keep the show a little bit shorter because today is Keilyn's birthday. So happy birthday to Keilyn. Everybody send her some love in the chat. I wasn't going to give her the day off for her birthday, right? So actually, Keilyn said she didn't want to. She said she wanted to spend part of her birthday with all of you, but I said, okay, well, we'll make it a short one so that you can go on to have some cake and fun for the rest of your birthday Sunday. So let's get into it. Yeah. Stay to the end for announcements. Hit those like buttons, hit that subscribe button if you haven't already. Please share this with anybody who you think might enjoy it. Annalie Finch, thank you so much for the super sticker. Let's jump right in, huh? All right. This is where Joshua has to do the technical part of the show. Malibu Table Maven, good morning. CC Crew, happy birthday, Keilyn. All right. First question of the day to kick us off. Here we go.
Hi, Josh. This is Misbehaving from Nottingham. Just want to say I love your show, and I totally love the concept of you answering viewers' questions each week. This is not so much a question from me this week as a statement, and the statement is, what on earth was going on with that defense opening statement in the Adelson trial? I just can't grasp it. They basically gave a motive for what happened. If you have time to comment on it, I'm sure you have other questions. I appreciate it. Love to you all. Bye.
Misbehaving from Nottingham, England. Thank you so much. Kicking us off, putting Nottingham on the map. There you are. And not so much a question as a statement, and I will agree with that statement, but let's talk about it a little bit. A lot of people asked about this. What was going on with that defense opening statement in the Donna Adelson trial? What was the strategy behind that? Was there a strategy behind that? Are they just throwing everyone under the bus? Why in the world do they got a photo of Dan Markel up? And why are they talking about him, referring to him as Danny? That is Jackie Fulford, who gave the opening statement for Donna Adelson's team. And the things that stood out to everyone is how much they conceded in all of this. Dr. Bullbutter says, yes, it was nuts. She said that the state can prove the Luis Rivera and Severo Garcia killed Markel. Then they said the state can prove that Catherine McBanois set it up through Charlie. So Charlie's under the bus as well. And her final comments were that prosecutors can prove and have proven that Donna Adelson's son, Charlie, paid to get the hitmen to kill Markel. All of that stuff they're willing to give up in opening statements, by the way. This was not one of your opening statements where it's like, please sit tight, please wait for us, please keep an open mind, wait for us to ask our questions, wait till the end of the trial before you make up their mind. They're willing to say, listen, a lot of this is conceded, but her final kind of words to the jurors were, but they are not on trial here, right? Now, I will say this. I feel like that was a strategically sound opening statement that was executed perhaps poorly. Here's the thing. They're not going to win any of that. They're not going to win creating any kind of doubt in jurors' minds that Luis Rivera or Sergio Garcia were the trigger men involved in killing Dan Markel. They're not going to convince people, and this is not the place for it, and they're not going to waste time on it trying to convince them that Catherine McBanois was not the middlewoman and that Charlie Adelson even was not the one who supplied the money. I think it's actually a sound strategy if you try to break it down. And there's Keilyn's tree that she put together for us. So everybody to the right of Charlie, including Charlie, they're saying, yes, fine. Already convicted, by the way. Why fight that? Why try to undo what's already been done? Already in prison for the rest of their lives. It makes sense, right? To say those people are the guilty people, not our client. And there's a big difference there. The government can prove all this stuff, but what they cannot prove is that one final step connecting Charlie to Donna. Now, I think that the government has done a fairly good job of disabusing jurors of that issue throughout this trial. I think they've done a fairly certain job of proving a pretty rock solid connection between Charlie and Donna. However, if you're Donna's attorneys, you got to start somewhere. And I think that was a good place to start. I think that the concept was, let's preserve some credibility. Let's not fight every battle here. Let's fight our battle. And our battle is the connection between Donna and the rest of these people. If the rest of those people go down, so be it. They've already gone down. Interesting. I know a lot of people sat there and went, what in the world? Well, hey, was it better than double extortion? I think so. I mean, at least it's something where jurors can appreciate that this defense is not trying to go for broke and say that everybody is innocent and nobody had anything to do with it. So thank you so much, Ms. Behavion from Nottingham, England, for kicking us off this morning. All right, who do we got next? Let's keep it rolling here. Arizona Gal 89 says, in the words of the late Judge Frank Caprio, oh yeah, by the way, rest in peace, great guy. Enjoy every minute of your life. Feeling grateful to share this Sunday morning with all of you. Thank you so much, Arizona Gal. What a nice sentiment to set the stage for the rest of today. All right. Let me get it going here.
Hey, Josh. This is NC Sale Dawn from Chapel Hill, North Carolina. First-time caller, long-time listener since I caught you in the early days on STS. I love your show, watch it faithfully, although usually not live, and just appreciate all that you do. I have been wanting to call for some time about the Menendez brothers because I have been staunchly in the camp of thinking that they should be paroled and felt like you leaned the opposite way. And so this is a good week after the 2 parole hearings. I will say that I'm rethinking my position a bit, given what we learned from the parole board about their very, very recent behavior in prison. I had not heard that before and pretty disappointed compared to what I had understood to be more model prisoner behavior. That said, I will say that I was very disappointed in your friend Matt Murphy's statement that I just heard this morning, that he essentially doesn't believe the essay occurred. That's really disappointing when you have renowned people like Ann Burgess saying it absolutely did. There's so much evidence to the contrary that it did. Pretty disappointed in that. So anyway, don't know if you have any comments. Thanks again. Appreciate all that you guys do.
Dawn from Chapel Hill, North Carolina. Let's put you on the map. Dawn, you say that you're a faithful listener. We appreciate that. A first-time caller, also appreciate that. But they usually listen to it on replay. So if you're not here, if you're here, hello. And if you're listening to it later, hello to you as well. Thank you so much for the call. Thank you so much for calling in for the first time. Yeah, the Menendez brothers. It's funny. This case, to me, is so fascinating. But it seems like something that we don't get a whole bunch of questions about. And I wonder if that's just people are done with it, done talking about it. I don't know, but I still find it a very fascinating case. And Dawn wants to know, how do I feel about it? Should I believe these men should get paroled? And she points out how Matt Murphy has been pretty outspoken about not believing their defense. And Matt's a good friend of mine. I think he's a brilliant dude. I think he's an incredibly smart attorney, and he's got some strong views about things. And I'm not going to sit here and try to defend Matt. I feel like he's a big boy and he can do that himself. But what I will say is that a lot of people who are, on the most extreme of being against this recent kind of movement in favor of the Menendez brothers, they point to the idea that the Menendez brothers changed their stories quite a bit. And that is true. At first it was they were trying to get away with it. Then it was, it was the mafia was involved. And then when it became abundantly clear that they were involved, it did seem as though this theory of abuse kind of arose. And at the time, I think it's important to understand that at the time, that was seen as kind of an en vogue sort of defense, and that a lot of people were bothered by this. Seemed to be the defense that a lot of people were going to in situations where they're just completely caught red-handed and left with nothing else. It's almost like we for a while there saw a lot of people pursuing a mental health defense that, oh, they're caught completely, they've got no other defense. Well, I was insane. And that was kind of the perception of the Menendez brothers. And some people still hold that position, that they don't believe that abuse took place. I will say this. I've done a lot of looking into this case and a lot of research on this case. I was part of a documentary with it. I really got deep into this case. I do believe there's evidence of abuse. I do believe that there is enough independent evidence independent of the brothers, saying that there was allegations and certainly circumstantial evidence of abuse. My feelings on this are that those two concepts are not mutually exclusive. I think that they could have been the victims of abuse, systematic and horrific abuse, and at the same time be guilty of first-degree murder. By the way, being the victim of abuse is not a defense, right? And in fact, they never argued that it was the defense because it doesn't legally exist. There is no kind of mitigation for my actions defense. But there is a defense of what's called imperfect self-defense. And that's what they originally tried to argue. They tried to argue that, listen, because of this abuse, we were so in fear of our lives that we did what we did. Now, it's not actual self-defense because there's no evidence that they were being attacked at the time. There's no evidence that they were being even in fear of their lives in the moment that they committed this crime. So they're saying our belief and our fear was honest yet unreasonable. And that's where you get imperfect self-defense. My feelings on this is, again, they probably should have been able to argue that. They did argue that the first time around. They got a hung jury the first time around. But in my view, if it's not imperfect self-defense, then it is first-degree murder. Keep in mind, too, they didn't come forward out of kind of the goodness of their heart. They came forward because they kind of messed up and got caught. Eric had told his therapist, thinking that would never be revealed. And then through a confluence of circumstances, it was revealed. But I think they fully intended on getting away with this at every point. And they were, by the way, getting away with it. Now, does that mean that law enforcement would not have at one point caught up to them? Perhaps, but they had disposed of the guns. They had disposed of any kind of forensic evidence linking them to the crime. For a long time, they were not considered suspects, even with their spending habits. I guess, I know I'm kind of going around in circles here, but I guess my feeling on the whole thing is this, you cannot consider this without also considering how horrific the crime was. We're talking about shotgunning your parents. We're talking about shotgunning your parents as they're sitting there watching television. Even if the father had committed horrible, horrible abuse, this is still a first-degree murder in the eyes of the law. When people are just sitting there minding their own business and you burst into the den and shotgun them to death, then go reload your shotgun, come back and put one more round in the side of your mother's head. That is a horrific crime. Do I feel that someone who has committed that crime deserves the death penalty in light of the mitigation of the abuse? No. But do I feel that that person should also be parole eligible? Also probably no. I mean, also probably I feel like what the jurors did may have been the right thing. And that's kind of my last point on all of this. I know I'm taking too long to answer your question, but my last point on all of this is that a jury spoke. I know we're 30 years removed from that, and there's been Netflix series and a bunch of different kind of changing of views and cultural shifting since then. But a jury spoke 30 years ago. A jury spoke, and a jury decided they should spend the rest of their life in prison without the possibility of parole. And I feel like that should mean something. And just because they happen to enjoy some celebrity status, I'm a little bothered by the fact that they're now looking at the idea of being paroled when there are many, many other people sitting in prison who I'm sure would love that same opportunity, but Netflix isn't doing docuseries on them. That probably would like to switch places with them. I don't know. I don't know how. I hope that answers your question. It's a great question, Dawn, and I'm glad that you answered it. And I know it's got a lot of people. I mean, here we are 30 something years later, still talking about this case. And I feel like it still presents a lot of really fresh questions that are still valid today. So thank you so much for that. All right, let's keep it rolling here.
Hi, Josh.
Actually, you know what? Let me thank Jenny. Sorry, I just saw that. Jenny G12, thank you so much for the super chat. Says, happy birthday at Tiffany. Thanks for enjoying part of the day with us. I'm mostly lurking, but I wanted to wish you the most wonderful day. She's thanking Tiff, but it's actually Keilyn's birthday. So we're gonna switch that over to Keilyn. Safe travels to CrimeTon, you guys, and all the crew that are going. Thank you so much. That's very sweet. And happy birthday, Keilyn. My bad. That's what I get for lurking and not paying complete attention. Keilyn's amazing. CC is lucky to have. We're very lucky to have her. Debbie892, thank you so much for the super sticker. We're so lucky to have her. We don't even let most other people know about her. Lulu loves Radiohead. Thank you so much for the super sticker. You guys are all fantastic. All right, now let's keep it going here.
This is Valerie in Valparaiso, Indiana, calling again. I've been looking for weeks and haven't seen anything on the Aaron Spencer case. There was a hearing on August 8th, supposedly, but I haven't seen or heard anything about what happened with him. If you could update us on that. Plus, you showed us how to join, become a member on your site, but I don't see anywhere how to set up so that I'm able to accept when people do gift memberships. So if you could explain that whole thing too, that would be great. Love your show. Never miss it. Thanks again. You guys are all great. Bye.
Valerie from Valparaiso, Indiana. Thank you so much for calling in. Thank you for asking that about these gifted memberships, Valerie. We wish that we had control over them. YouTube does not let us. It's kind of part of the YouTube algorithm. You can gift them, and then it's like the lottery. It goes to whoever, and I have no idea how it works. I've even gifted them before and received it myself on other channels. So I don't know how that gifting of membership works. We cannot even give a membership to someone. Like, we can't say, hey, we don't want to gift this to the world. We just want to give this to this one particular person. YouTube won't allow us to do that. So they also make it incredibly difficult if you're trying to sign up to the membership program and do that from your phone or anywhere else. So the easiest way that we've found is if you go to thecourtroomconfidential.com. Just go to our website, thecourtroomconfidential.com, click on the membership tab, and that will allow you to directly become a member of the channel. And we hope that you do. We really put a lot of work into making it something that you all enjoy and feel that it is worth your generosity and efforts. Just make sure that you have that checked. I'm not sure what that means. Oh, click on that button is what she's saying, right? All right. Okay. All right. But Valerie, you asked a question about Aaron Spencer, which is also another fascinating case that's out there. Aaron Spencer, for everybody who hasn't been following this, is a gentleman out of Arkansas. He's got a 14-year-old daughter along with a couple of beautiful looking turkeys there. And I think those are turkeys, right? He had his daughter was every parent's nightmare. She was a victim of abuse by a non-family member, just stranger to their house, a man by the name of Michael Fossler. That man was arrested. That man was on, I believe he had pending charges against him, but he was out of custody. In the middle of the night, Aaron hears barking. He goes into his daughter's room. He's not there. Can you imagine the nightmare of waking up to your dog barking, going into your daughter's room, and she's not there? 1 o'clock in the morning, by the way. He immediately calls 911. He tells them that my daughter's been kidnapped. You can imagine the fear and panic going through that man's heart. And he decides he's going to go out looking for her because he has a prime suspect in his mind, and that is Michael Fossler. And he knows what his car looks like. And he finds his car, and he pulls over his car, stops his car. And then, according to Aaron Spencer, the way it goes is he, at gunpoint, orders Fossler to let his daughter go. Apparently, he does not let her go. She tries to get out of the car, and he tries to stop her. And then at one point, according to Spencer, Fossler charges him, and Spencer unloads his weapon on him and kills him. It's a case that, just hearing that, everybody's losing their minds that this man is actually being criminally prosecuted for second-degree murder, by the way. Second-degree murder, something that could put him in prison for his life. And that's what he's being prosecuted for doing what any red-blooded father in this entire country would do, myself included. This is out of Lonoke County, Arkansas. What's the latest on the case? He's facing second-degree murder. There is a petition that has received 195,000 signatures from that community telling the DA there, stop it. Stop pursuing charges against this man. But trial is set for December of this year, December 17th of 2025. I hope that this groundswell of outrage will do something about all of this. We don't know all of the circumstances of this case. I think that we can all agree that we might feel very differently if Fossler, if there was evidence that Fossler got out of his car, hands above his head, said, "I'm so sorry, please take me in, arrest me," and Spencer just executed him. But everything that I've heard says that may not be true. So, in my view, according to what we know, this man is a hero, and I feel a lot of you are saying the same thing. We will keep a close eye on this one. I am flabbergasted by what's going through the DA's office, and I'm trying my level best to give them the benefit of the doubt, because otherwise you're left with a very sinister set of circumstances here. All right. Thank you so much, Valerie from Valparaiso, for asking that question. Mary Jubinville, thank you so much, says they were both over 18, could have moved on moved on their own. Many people are abused and don't do that to their parents. Again, we're talking about the Menendez brothers, and that's something that many people bring up. They were adults. They were adults. They had alternatives. They could have done many other things. And I realized they felt trapped and and listen, that's again why my whole point is they're not mutually exclusive. I feel like at one point you can both agree that being the victims of abuse is horrific and sympathize and empathize and understand what they were going through. You can feel that their father was a horrific human being if all of those allegations are true. And you can hold those same thoughts in your head and also hold the thought in your head that what they did was incredibly wrong, first-degree murder, and probably should earn them life in prison. But thank you very Mary Jubinville. CJ in LA says, happy birthday, Keilyn. We appreciate you so much. Happy birthday, Keilyn. That's a good day for Keilyn. Now I know why she wanted to do Sunday Fun Day. She didn't want to miss out on all these happy birthdays. Fala damn it says, just became a YouTube member. Thank you so much. Appreciate that. And Crazy Mom RN, thank you for gifting the membership. Misconduct for gifting a membership as well. Appreciate the generosity of all you guys. Alexis MC220, thank you so much for the gift of a membership. IGG Rocks has been a member for 6 months, just getting started on my CC journey. I love it. Glad to have you. All right, let's keep it rolling here. I'm trying to keep the pace quick so I can get through as many of these as we can.
Hello, Josh and everyone. Happy Sunday Fun Day. This is Michelle from Phoenix, Arizona. I was wondering what qualifications it takes to be a judge. Thank you and have a great day.
Great question. What does it take to become a judge? Well, not a whole heck of a lot. Probably not as much as it actually should is the answer to that question. The answer here in California, it's obviously different in every single state, but here in California where I practice is one, you have to be a member of the bar, meaning you have to be an attorney. You have to have passed the bar. You actually have to be a practicing, meaning you have an active bar card. So in other words, you can't have allowed your bar fees to lapse and you haven't practiced as an attorney. You have to be in good standing and you have to have 10 years experience. And all that means is 10 years with an active bar card. That does not mean that they go and check how many cases have you actually tried? How many clients have you actually handled? What is your experience? Are you a divorce attorney? Are you a contracts attorney? Are you a criminal attorney? None of that stuff. 10 years experience, good standing, active bar card, and you can become a judge. Now, doesn't mean you will become a judge. There's two avenues to have that happen. You can either be appointed by the governor, and usually the governor is looking for people in good standing with a good reputation who have experience. There's a lot more vetting process that goes on with all of that. I receive emails all the time from what's called the Jenny Commission, where they're asking for, have you ever had an experience with this person who the governor is considering appointing as a judge? And it may be somebody that you've, worked with, somebody that you've been opposite of, and they're asking for your input. Is there any reason that you feel might disqualify this person? But the other way you can do it is through election. Judges have their seats come up for election every once in a while. And every once in a while, there might be an open seat where a judge is retiring, or there might be a seat where you feel like you could challenge that judge. And that's open to anybody, as long as they have those qualifications. That doesn't require as much vetting. It just requires you to run and have enough money to get yourself on the ballot. That being said, that leads to some interesting outcomes. I will tell you a quick story. When I was a very young DA, a baby DA, as they refer to us, I had a judge who was a first-time judge. And she was, I really hope not watching. And she was, at the time, what's a very diplomatic way of saying this? Did not know what she was doing. And that became abundantly clear. And the reason for that is that this judge had an active bar card for 10 years, but had never actually practiced law, was my understanding. Instead, she owned and operated a bagel shop, and she kept her bar card active. She had enough money to run for judge. She ran for a seat against an opponent who was not as well funded as her, and she won that election and became a judge. This was a person who had never done a trial, never knew, never worked on either side of the V, never a prosecutor, never a defense attorney, had really zero idea what they were doing. So she won her judgeship. They sent her out to my assignment. I actually did the first trial that she ever had, was with me in front of this judge. And it was an experience. It was one of those things where, there's kind of a language that you speak when you're an attorney. You all kind of, you refer to, oh, this is 1101B evidence, or I'm going to run a 352 motion on that, or whatever. And you all kind of speak the same language. And it was like, a lot of hand holding, and from a judge who didn't. It would have been one thing for the judge to just be like, listen, guys, here we are. Here we find ourselves here at these crossroads. Give me a little bit of help. Help me help you. It was kind of this air of, I know what I'm doing. Don't tell me otherwise. And that was disastrous. As far as I know, still a practicing judge. So there you go. That's the answer to your question, Michelle. Not everybody who's sitting on the bench in a black robe entirely should be sitting there if we all had the ability to really vet these people properly. Thank you so much. I will tell you, that is the one thing that was the biggest eye-opening experience of becoming an attorney, was realizing how bad some of these judges actually are. You think of them as being these all-knowing, all-wise people, and a lot of them, not so much. And I'm trying to be nice. Grizzly, Gizela, thank you so much. Grizzly True Crime. Hello. Hey, everybody. Happy Sunday. She's about to go on a jog, is my sneaking suspicion. All right, let's keep it rolling here.
Hi, Joshua. This is Linda in Red Bluff, California. I hope I can ask this question in a way that makes sense, but I've noticed that in a lot of cases where there are co-conspirators, that prosecutors will spend a lot of time presenting evidence that more directly implicates co-conspirators who've already been convicted than the one being tried. For example, in the Donna Adelson case, the evidence presented on day one when she was questioning Rivera about like who rented the Prius, who bought the gun, asking him about, what they did on the day of the shooting. Why would that matter when it doesn't directly implicate Donna in any way? Why would they spend time on that when they could get into evidence that does directly implicate her? I hope that makes sense. Thanks.
It does make sense. Thank you so much, Linda. Linda from Red Bluff, California. Let's put you up on the map there. Where's Red Bluff? Oh, there we go. We're above Sacramento. Nice. Gizela says, I did just take you all on a jog. Okay, good. I'm keeping tabs on Gizela's fitness journey. All right. Linda, thank you so much, from Red Bluff, California, asking about Donna Adelson, Luis Rivera. Why are they spending so much time? And I think what you're asking out of this is, why are they spending so much time proving up stuff about what Luis Rivera did when he's not on trial, to the point of the opening statement? Why are we spending so much time talking about his bad background and everything that he's ever done when he's not the one who's on trial here? He's been found guilty. And why? Well, a couple of reasons. One, remember, this is, I've said it before, I'll say it again, I think the greatest test to date for the prosecution, because they have to prove everything. You cannot just start out with, by the way, ladies and gentlemen, a murder occurred and that is proven. Nobody's stipulating to that. They have to prove everything. They have to prove Dan Markel was murdered, who he was murdered by, meaning the Luis Rivera and Sigfredo Garcia, or the triggermen. They have to prove what was the connection to the Adelson family through Catherine McBanwell. They have to prove that Charlie Adelson provided the money, and they have to prove that Charlie and Donna spoke and came to a meeting of the minds about all of that, and that it all worked its way back down to the triggermen as well. All of those things have to be proven, and they've done that with remarkable alacrity in this case, because we're moving along so quickly and so, laser focused on getting to the Donna part of the whole case. But the other part of that is that this is a conspiracy case. And in a conspiracy case, you need to prove a few things. One, you need to show agreement. So there needs to be some sort of meeting of the minds between Donna and somebody else. In this case, it's Charlie. You need to show specific intent on Donna's part. In other words, she needs to have intended for Dan Markel to be killed. This isn't some sort of, how would I say, a general intent. It's not the general idea of she's involved in taking care of the problem, right? Just go take care of the problem, but that she knew that meant murder, an unlawful goal, murder. And there has to be an overt act taken by someone in that conspiracy, some step in furtherance of meeting that goal. Well, each of these people has an overt act. Luis Rivera, his overt act was being a part of the actual murder itself. Sigfredo Garcia, same with him. Katie McBanwell, they each had an overt act. And so we need to talk about the steps that each one of them took to prove up that entire conspiracy so that Donna can be a part of it. So all of the acts of these other people, it's the better way to think about it is everybody's back on trial. But this one, the question only being presented to the jury here is about Donna, but everybody's back on trial because they're all part of this conspiracy. So Linda, thank you so much for asking that question. I know it's something that a lot of people have been curious about, because conspiracy itself, by the way, attorneys don't understand it. It's a very complex theory of culpability, but being used very masterfully by the prosecutors in this case. Thank you so much, Linda from Red Bluff. All right, let's keep it moving here. All right.
Hi, Josh. Eva from Bochum, Germany calling. I've been following the Kohberger case closely and have a question. The prosecution only mentioned deleted data, but Celebrite's forensic team found buried deep in Kohberger's phone autofill search terms such as raped, forced, PDFs on serial killers, and disturbing selfies. All that stuff that has been shown on Dateline. The kind of data may not have been safe to use in court depending on how it was recovered. Do you think the FBI could have strategically leaked that info through Dateline to create psychological pressure, knowing Kohberger tracked media obsessively, especially with his close relationship to Mother? And the idea of her seeing his fantasies might have been more devastating than a trial. I wonder, what would you think? Thank you.
Eva from Germany. I didn't hear, I had a tough time telling where you were in Germany. So I'm going to just say somewhere in Germany. So we appreciate you calling in, Eva. If you're listening, please tell us the city. We'd love to get it right. But thank you so much. This is about Bryan Kohberger. I love this question. This is why I love Sunday Fun Days. You guys always ask questions that I never would have thought of, and you think about these cases in different ways. So Eva's question is, do we think that the FBI may have been involved in leaking some of the information to Dateline in order to, and I think Eva's question is, in order to pressure him to take a plea? Would his mother perhaps see some of this stuff and realize the devastating case against her son and somehow pressure Kohberger? Or would he see it and realize that his proverbial goose is cooked and to take a plea? Great theory, interesting question. Of course, we're talking about Ethan and Keilyn and Zaina and Madison. But interesting theory, but I don't think true for a couple of reasons. One, the FBI doesn't do that kind of stuff. I mean, not to say that the FBI is infallible, but I just do not see them playing these types of games. I do see them doing that if he were not captured and they were trying to smoke someone out and they wanted to release strategically some information to put the pressure on somebody. Perhaps he was a suspect at the time and they wanted to try to get a confession out of him or something like that. But I don't see them doing that for a person who's already in custody, charged with a crime and about to approach trial. It just doesn't, there's no advantage to me. And that's why I've always felt like I don't understand why the prosecution would do this. There's no advantage to them for doing this. And the other thing about this is I don't think he cared about public opinion or the evidence against him. I think he cared. And I think what finally turned the tide is he ran out of defenses. He ran out of arguments to make. The alibi defense, gone. DNA, nothing they're going to be able to do about that. The sheath is coming in. The DNA is coming in. The IgG is not going to present an issue. Third-party culpability, his last kind of chance at mounting an actual affirmative defense in this case, was shut down within days of that plea agreement being entered into. I don't think that's a coincidence. I think that was what was finally the straw that broke the camel's back. They said, I fully believe this, that Ann Taylor lost that motion, may have been having conversations with him before this about taking a plea, about avoiding the death penalty. That was their biggest concern, was avoiding the death penalty. And I think that sometimes with a client, they need to feel like all hope is lost before they can wrap their heads around taking a plea. And all hope was lost when they ran out of that third-party culpability defense. And I think they lost that. And I think she turned to him and she said, what do you want to do? We've got nothing to argue. You're going to be found guilty. You killed 4 beautiful people in the middle of the night by stabbing them to death as they slept. They're going to give you the death penalty. What do you want to do? And he said, okay, see if they'll take the death penalty off the table. I have no information to support this other than my own gut instincts. And that's what I think took place. So I don't think it was the FBI, Dateline, anything else. I think we would have been heading into trial had they won that third-party culpability. I fully believe that. Had they won that third-party culpability and they could have made that argument, we'd be talking about a trial right now. Thank you so much, Eva, from somewhere in Germany. Appreciate you. All right, let's keep it rolling here. John W. says Germans and their conspiracy theories. How dare you, sir? As a German myself. Southern CJB says, how is no one talking about, Fraser Baum? Oh, yeah, that's an interesting case. Alan Jackson's working on that case here in Southern California, involving a really tragic, horrible accident that took place involving the loss of 4 beautiful lives here in California. Catherine Rieger as a cupcake for Keilyn. How very sweet of you. That's very kind and generous of you. Keilyn's face just lit up. She appreciates it. All right, let's keep it rolling here. Not my fault.
Hello, Courtroom Confidential. Is Nina from Sweden and a town called Vimmerby again. I have a question about the little child, the little toddler that is missing and probably murdered child outside of Coachella, I believe. If they won't find his remains or body, how will they proceed? Will they get a conviction from on the parents without the body? Now I know that the carpet that they found had blood on it, but if it wasn't the child's blood, it wasn't some other person's blood, let's say the mother's, can they charge and can it be a conviction on the parents if they won't find the body? Thank you.
Nina, thank you. From Vimmerby, Sweden. Let's put you on the map. There you are. Talking about the Emmanuel Haro case. What a sad, sad case. You know, it's this. I mean, there's many sad things about this case, but the part that just breaks my heart is that we all knew. We all knew from the second the report started to come out about this, and we saw that mother and father in that press conference talking to the news. We just knew. We just inside all of our guts. We just, there it is. The second I saw that happening, I'm like, oh boy, they killed that little boy. They killed that little boy. It's just pathetic and evil and awful and horrific. And the dad sitting there with that sad little sign. The whole thing just makes me sick. So Nina's question is, this is a question that we got from a lot of people. So I'm kind of using you, Nina, as an example to answer a few other questions we got about no body cases and how are they prosecuted and what are the difficulties of all of them. And so I'm going to kind of generally answer that in regards to this case as well. But first of all, yes, they are, for the most part, circumstantial cases, meaning you don't have direct evidence. You don't have an eyewitness to the crime taking place. You don't even have the body. You don't have an autopsy. You don't have a means of death. You may be able to call this a murder, but no medical examiner has classified it as a murder, and no medical examiner has said that the cause of death is asphyxiation or blunt force trauma or whatever it is. Yes, there are inherent built-in difficulties to all of that. So you've got, first of all, the question of, is the person dead, is always going to be the question, right? You're always going to have some argument, whether implied or explicit from the defense, saying, we don't know if this person's dead. We don't know if this person was kidnapped. We don't know if this person ran off. I'm speaking obviously generally. Then you don't have the means of death. You don't know, okay, fine. If they believe the person was killed, well, then how? How is this person killed? This is the burdens on the prosecution. They're the ones who have to prove everything beyond a reasonable doubt. Well, they can't even prove to you beyond a reasonable doubt how this person was killed. And in these types of cases, this one not being an example, but a lot of times in no body cases, they're cold because maybe a lot of time has passed since the person was declared missing to when they actually decide to bring charges against someone. We see that oftentimes. So there's a lot of difficulties. They are seen as being the most difficult type of case to prosecute. And in fact, for many, many years, they were not. It was kind of groundbreaking when the first no body cases started to be prosecuted. Well, they do it through circumstantial evidence by asking the jury very logical questions and presenting evidence circumstantially to prove a lot of things. First of all, in the case of Emmanuel Haro, babies don't get up and run away. If the baby's not around, that means the baby has likely passed, right? Babies don't run off. The baby was in the care of his parents. The last time he was seen alive was in the care of his parents. This is Jake and Rebecca right here. They also lied to law enforcement. They changed their stories. There was inconsistencies in their stories, a consciousness of guilt there. And there was the prior bad acts of Jake. We know that he had a prior arrest for some horrible abuse against a child of his own, an infant from a prior marriage that should have landed in prison. That was a whole topic we had discussed earlier. So, and there may be, though there's some question about this, there may be some jailhouse confessions taking place on all of this. So they have a fairly good case. The other thing about no body cases that is interesting. It presents one advantage to the prosecution that they would not otherwise have. And that is, and it's not entirely true in this case, but think about a case where you hear about a wife goes missing. You know, Morphew comes to mind immediately. What is that other case? Simpson out of Texas is another one that comes to mind. When trying to prove to the jury that this person has not run away and is in fact dead, the prosecution is able to bring in a lot of witnesses to talk about the habits of that person. Well, those witnesses become quasi-character witnesses. When you're talking about a wife and why she didn't run away and abandon her children, you can bring a witness to the stand to talk about how much she loved her children and how often she checked in with her children and how often she would immediately return a phone call and how she checked in with her mother every single day, and all of these kind of habit pieces of evidence that otherwise would not be relevant in a straightforward murder case where you have the body, because you don't need to prove then that the murder actually took place. You have the dead body to prove that. And all of these other witnesses talking about what a wonderful person the victim may have been is not relevant at that time. So there is that one kind of small, interesting wrinkle that presents itself for the prosecution. But usually in these no body cases, though they are difficult, they can sometimes have resoundingly powerful circumstantial evidence. So thank you so much, Nina from Vimmerby, Sweden, for asking that question. All right. Fala, damn it. Love saying that name. Says, thank you so much for gifting the memberships. I appreciate you. All right. Let's keep it rolling here. What am I doing wrong? Why do I feel like I skipped somebody? All right, here we go.
Hi, my name is Debbie. I live in Townsend, Tennessee, the peaceful side of the Smokies. I would like you to look at a case that was in Knoxville, Tennessee when I moved to Townsend. Channon Christopher Newsom, January 6, 2007, two University of Tennessee students, the way they were murdered and what happened. You just can't even believe this happened. The dad of Channon, the daughter, rocked in the courtroom the whole time, just rocked to try to calm himself. And security stood next to him. This is all recorded. You could see this. It was videotaped. It was so big. It was so awful. I could see how you get when you talk about children. These were, I think they were 1920 students. They were hijacked. Their car was hijacked. And what these guys and this crew of people did to them and how they did it, it's tears in my eyes. So if you don't want to talk about it on your show, just look it up yourself. In honor of these kids, just to recognize what they went through. They were great.
Oh, Debbie, sorry you got cut off there at the end. Debbie from Townsend, Tennessee. Thank you so much for calling in. I appreciate that. Let's put Townsend on the map. Tennessee in the house. Thank you for bringing this case up. I'm going to tell you guys right now, graphic content warning on this. We're going to talk a little bit about it. I'm going to not try to get overly gruesome on the whole thing, but I'm glad that Debbie brought this up because there are many, many cases like this. Horrible, horrific crimes that take place that never make the news. No one ever hears about them. I worked on a case, I'll tell you guys one time about, on another episode that was very similar to this, about a young girl, college girl here in California, went to the ATM, got kidnapped. Horrible, horrible things happened to her. And that's what happened in this case. So I'll try to get through this quickly. If you guys don't want to listen, you've been warned. But Channon Christian is 21 years old there on the left, and Christopher Newsom 23 years old. And they are in Knoxville, Tennessee. This is in January of 2007. They are carjacked and kidnapped. And what follows can only just be described as evil because it served no purpose. There was no kind of like, get us more money. We're going to kidnap you and hold you for ransom. It was a group of evil people who decided to kidnap these two young kids and then just do horrific things to them. Christopher was, first of all, both of them were R-word more than once, including Christopher. He was eventually bound and led by, there was evidence that he was led by a dog leash down the road until he was put onto his knees and executed with a shot to the back of his head. He was made, essentially, in other words, to walk to his own execution. And that was merciful when you compare it to what Channon went through. It is believed that she died, and this is according to the medical examiner, died succumbing to hours of sexual torture was the way that it was described. She was repeatedly assaulted, all about her body. When they were done, they poured bleach down her throat and all over her body to try to hide the DNA. This is in 2007, so they were aware of that kind of evidence. And then, and this is the part that I did some research on this, but probably could have spent hours more. She was eventually suffocated to death inside of the garbage disposal in the kitchen. I'm not even entirely sure as to how that all took place. But this case went to trial. They were all convicted. There were several people involved. It went to trial. Their convictions were overturned. It went to a second trial. They were again convicted. The reasons for the overturning of the conviction, it was a long and tortured kind of legal process dealing with the judge, had apparently committed crimes unrelated to this, substance abuse and everything else. They went back and forth within the Tennessee Supreme Court, finally deciding that just because the judge had issues outside of the trial doesn't nullify the trial itself. Again, I don't want to spend too much time on all of that, but end of the day, Latalvius Cobbins received life without parole. Lamarcus Davidson received the death penalty. George Thomas received life, and Vanessa Coleman received 35 years, and Eric Boyd, who was kind of a lookout, received 18 years. Again, it's on top of all of the other nightmare. It's always fascinating in a very grotesque way to me when you have a group of people who commit these types of horrible torture, murder sort of cases. So, Debbie, thank you so much for kind of highlighting a case that we might not otherwise have an opportunity to talk about. And, you know, I hope God is with their family members and helping them through. You can understand why the father was as tortured as he was throughout this entire trial. All right, let's keep it moving along here. We're trying to keep a swift clip. Want to get Keilyn out of here so she can enjoy her cupcakes and birthday. And I apologize, guys. I'm just not able to get to every question that you guys asked this week. Forgive me. Don't let that discourage you. If I didn't get to your question this week, ask another one next week. And I promise you, I will try to get you the next time around. All right. Where are we at here? Here we go.
Hi, Josh. It's Pam from Michigan. Quick question about Wendi Adelson. Is the prosecutor keeping track of all the testimony that Wendi has done for perhaps perjuring herself or saying something that's untrue that would validate the order that she's got to not be charged for anything? Just thinking that there are some times when defense is cross-examining Wendi that Georgia just kind of like let things go that I think I would have said something about, or I'm wondering if she's kind of like doing a behind the scenes track of everything. And then when she hypothetically does need to go or want to go arrest her, she can say, well, because of this, this, and this, you validated all these, your protection order and everything like that, and perjured yourself. And so we are bringing charges against you. Just something I kind of wondered that during the testimony yesterday that I was thinking about, and maybe you have an answer for us. So anyway, can't wait for Sunday. Should be lots of information on the trial this week. Can't wait to hear all the answers. Have a great Sunday.
Pam from Michigan, thank you so much. Always good to hear from you. Great question. Again, another question that a lot of people ask, very similar question. So I'm going to kind of use Pam as the example for all of that. There she is, Wendi. Just imagine that with like a big target over her face, according to the prosecution. What's going to happen with Wendi? And a lot of people said, we understand now her immunity agreement. We understand that they can't use what she says against her or what they've derived from what she says against her. But part of her agreement is that she testifies honestly and truthfully, Ritter. Well, what if she doesn't? Is Georgia Kappelman keeping tabs? And is she keeping a list of all of the times that she may not have lived up to her side of the bargain with this immunity deal? And is she going to use that against her? And the answer is yes and no. No, because they are not going to bring a case against Wendi just based upon what Wendi says here on the stand. That would lead to so many appellate problems and issues. This would be litigated till the end of time about whether or not the prosecution would be invalidating their immunity agreement. And you could say, well, listen, she invalidated it herself. Yes. But think about if you're the next defendant that gets offered an immunity agreement. You're going to say, no way. No way, dude. We saw what you did to Wendi Adelson with her immunity agreement. Anytime she messes up or misstates or mischaracterizes, you're going to say that's a lie and invalidates the whole thing. Nowhere I'm getting anywhere near that stand. I don't care what you do. Go ahead and find me in contempt. They're not going to do it. They're not going to risk it. They're not going to put the hands of they're not going to put their case in the hands of that. If they're going to indict Wendi, and we'll get to that later, they're going to do it based upon a bunch of other evidence. Now, what's the yes part of that? The yes part of that is, of course, they're keeping tabs on it if Wendi decides to testify. Because if Wendi decides to testify in her own hypothetical future trial, and she takes the stand as the Adelmans are predisposed to do and tries to defend herself, then they can use everything that she's ever said as impeachment. If she says something different on the stand during her own hypothetical trial, they can't impeach her with everything she's ever said before in any of these other trials. So it's not that they cannot use it ever. It's that they cannot use it to mount the foundation of a prosecution against her. And they're not going to, because they're too smart for that. And they're not going to be caught up in some sort of case that's based. So you imagine if they tried to bring a case against her and that's all they had is her statements that she made in court under the auspices of an immunity agreement, and a judge tosses it all out, they're done. They're done. So they're just not going to do it. I get why it frustrates everybody. I get why everybody's keeping tabs themselves. Not going to happen. Not going to happen that way, at least. But great question, Pam. And thank you for asking it. And thank you for calling in. All right. I don't know why I got overheated about that one, but who knows? Let's keep it moving here.
Hi, Josh. Jen from Boston. I left a message last Saturday about the Adelson case. I didn't realize the cutoff for Sunday Fun Day is on Fridays, which makes a lot of sense. I'm a rookie, Josh. Anyway, so much has unfolded in court this week already, and I'm calling at 7 a.m. on Wednesday, so who knows what's going to happen. Donna's attorneys have implicated both Charlie and Wendi now. So do you think Charlie will fall on the sword for his mother and point the finger at Wendi, realizing his appeal won't go anywhere? In Charlie's trial, I think he explained the payments from the dental practice were because Katie needed to be employed to receive government benefits for her children. So if Donna goes down the same path, would that indicate to you that Charlie's going to testify to the same? So much other evidence against Donna that this wouldn't even make sense, but clearly this family doesn't make sense. So hard watching the Markells in court again. They're entangled with this crazy family for all these years. Poor Dan and his kids. My heart went out to Rob Adelson too. He did the right thing, but you could see how painful it was. So what's going on here, Josh? Thanks to you, Tiffany, Keilyn, and the mods. I don't know how you juggle everything, all the back-end prep work for the shows, the chats flying in, wrap-ups, guests. Wow, you do a great job. Have fun at CrimeCon. Congrats on the award nomination. Go get it, CC team. Thanks, and have a great one.
Jen, thank you so much. Appreciate all those kind words. Jen from Boston, Massachusetts. Let's put you on the map there. Again, another question that a lot of people were curious about. What is Charlie going to testify to? How will he testify? Will he testify? Again, I don't mean to pat myself on the back here, but I don't think he's testifying. I mean, the prosecution has rested. He has not testified. First of all, I don't even think the defense has a subpoena for him because that caused such a kerfuffle. Uses that word whenever I can. The first time around when they were setting this for trial about whether or not he would testify and being represented by Donna being represented by his prior attorney, Roshbaum, and all of the implications of that. And I realized that they got his sorry butt out of prison and brought him all the way to Tallahassee in anticipation of testifying. But I just don't see it. I don't see it. Doesn't mean it doesn't happen. Doesn't mean that there aren't things that I can't see. There are certainly plenty of strategies and people playing, 3D chess when I'm over here playing checkers, but I just did not see the advantage to the prosecution because of all the reasons that you point out, Jen. What is he going to say on the stand? Is he going to implicate Wendi? Is he going to absolve everyone and say it was all me and nobody knew anything about it? Is he going to stick to his story that he did during trial? Is he going to abandon the story that he made during trial? He's got an appellate issue still at play. Will he take the fifth? Will he, he's such a wild card. When you're the prosecution, I mean, they talk about this, that rule number one in cross-examination or just examination of a witness is don't ask a question you don't know the answer to. Why I would say that applies even more so to don't call a witness that you don't know what they're going to say. He is not friendly to the prosecution. They don't know what's going to come out of that man's mouth. And probably most important of all, he's a liar. So what are you going to do? How are you going to play this as the prosecution? What part of his testimony are you going to ask the jurors to believe? You've already called him a liar. You believe that some of at least of what he's going to testify to is going to be lies, but you're going to ask the jury to accept some of it as proof of something and then disregard other parts of it. You don't need him. You don't need him. He's not helpful. He's a wild can, a loose cannon, and he's a liar. And for all those reasons, I was surprised at the idea that there was even the contemplation of calling him to the stand by the prosecution. And I think that's the way it's going to remain. I think he's just hanging out in Tallahassee for a few more days. I believe Josh called him a lying liar that lies. That's what he is. He is. He is a lying liar that lies. That is what that man is very good at. He was a very poor dentist, but a very good liar. Not even a good liar. So thank you, Jen. Great question. Thank you so much, too, for the kind words. But yeah, I think that's how it ends for Charlie. I don't think we're going to see him this time around. But I think we will see Donna. So buckle up. There's still going to be some fireworks next week. All right. Let's keep it rolling here. Oops. Hold on.
Hi, Josh. It's Granny Detective. I'm concerned about the Aaron Spencer case and wondering if it would be better to have him go through the jury process and get a not guilty, or would it be better to claim temporary insanity? I mean, he did shoot him. It's hard to prove self-defense in that case because the other person is dead and didn't have a weapon. So would he be better off trying to go with temporary insanity instead of hoping that the jury will just find him not guilty? I don't blame him for what he did, but I just wonder why or which would be the best way to go. Look forward to hearing your answer. Cheers. Bye.
Granny Detective from Calgary, Alberta, Canada. Let's put you on the map. Granny Detective, you may be a detective, but you're thinking like a defense attorney, and I like it. Very interesting way of considering this case. This is, of course, Aaron Spencer. There he is with his turkeys. Always love to see him. We talked about the circumstances of this case, but Granny Detective brings up something interesting. This is not straightforward self-defense. The man was not armed. Bear that in mind. Put aside, by the way, all of the horrific stuff that Michael Fossler did, okay? And just bring yourself to that moment. You have an armed man and an unarmed man. What could that unarmed man do in that situation that would put the armed man in fear of his life? That's the question. When you're talking about self-defense, you have to have reasonable expectation of immediate threat of life, okay? Where is that? That's a problem. Granny Detective sees that. Granny Defense Attorney sees that there might be an issue here with self-defense. And she says, well, then why not pursue some sort of temporary insanity defense? Why not say he is incredibly stressed? It is the trauma and turmoil of the moment, his daughter being kidnapped. He's in the man's car. It's 1 a.m. in the morning. He lost his ever-loving mind and shot this man. Not a horrible concept. Here's why I think they won't pursue it. There's a couple of reasons. One of them's legal and one of them's not. The legal reason is that temporary insanity is a defense to intent, whereas self-defense is a complete defense, meaning if you're able to prove self-defense to a jury, that person is acquitted. That person walks. It is a complete defense to the crime of murder. Temporary insanity just mitigates the intent required for the second-degree murder, meaning he wouldn't be found not guilty. He would still be found guilty of something and likely go to prison, which we don't want to do with this man. We want to give this man the keys to the city and name a weekend after him. We don't want him going to prison. So for that legal reason, I think his team is going to pursue this self-defense. You can also claim self-defense for defense of others. He could have felt like maybe he wasn't in immediate danger of harm, but his daughter certainly is, who's in the car with this psychopath, who's already assaulted her one time and is now not letting her go. And who knows what he may have seen in her hands, or who knows what the daughter may have been screaming in that moment. But the other reason that's not really so much the legal reason, it's that you find me 12 people willing to convict this man. If there is anybody sitting on that jury who's got children of their own or even nieces and nephews, they're not convicting this man. No one is going to hear the facts and circumstances of this case and convict this man. I just don't see it happening. And that's, again, not to say that the prosecution should not pursue murder charges when even a horrible person gets killed. I get that. I've done that job. But how are you going to convince these people? How are you going to convince these people that what this man, he's going to, by the way, testify. And he gets up on the stand and he talks about waking up in the middle of the night to the dog barking and his daughter's gone, and the fear going through his brain in that moment, he jumps into his car like a goddamn hero to go out and find her and save her life, and finds this man, and he's with the man, the monster that he was his greatest fears were, finds him. Come on. You make that closing argument as a prosecutor. Not going to happen. Never going to happen. And so for that reason, I think I'd be shocked if this actually goes as far as trial. But if it does, my guess, if I'm hedging my bets, my guess is they offer him something with no prison time. They give him some sort of slap on the wrist, put him on probation, say, please don't go around being a vigilante, but we're not putting you in prison. Talk to the governor. Somebody needs to get involved. All right. Great question, though. Thank you, Granny Detective. Let's keep it rolling here. Oh, True Crime in a Minute. Thank you so much for the gift of memberships. Appreciate that. So generous of you. C Shell Arizona. Thank you so much for gifting the memberships as well. Appreciate everybody. Helping everyone join the CC crew here. All right. Here we go.
Happy Sunday Funday, Joshua, Tiffany, Keilyn, Moz, crew, guests, everyone. Felicia K. Mayo, Humboldt, Tennessee here. Joshua, in the jury instructions, as we heard in the Grady Gotti case, Judge Everett mentions inference, and that you can apply inference if you can get it from the evidence that's provided. But we hear attorneys often saying you are not supposed to apply inference. So I would like you to explain that further, and please do it like I'm 5. Thanks. Hope y'all have a great Sunday fun day. Bye.
Alicia K. Mayo from Humboldt, Tennessee. Let's put Humboldt back on the map there. Thank you so much. Always great to hear from you. And a great question. What are inferences? Are they allowed? Yeah, they're allowed. What's not allowed is speculation. What's not allowed is drawing conclusions based on kind of gut instinct. But inferences are just it's what you use for in circumstantial evidence. It's what you're taking a piece of evidence and you're taking one more kind of logical step away from that. You're drawing an inference from that evidence. Here's a good example. I want to show you a jury instruction. This is called the corpus delicti rule, and it applies here in the Adelson case, but it's also this is from the California jury instructions, but it's something that's going to become an issue here in this case. The defendant may not be convicted of any crime based on her out-of-court statements alone. In other words, they cannot convict Donna Adelson just based on things that she said to other people. You may rely on the defendant's out-of-court statements to convict her only if you first conclude that other evidence showed that the charged crime was committed. So there's got to be something else. In other words, people can't go around running their mouth saying, yeah, I killed Dan Markell. You have to have some evidence. Now, that other evidence may be slight and need only be enough to support a reasonable inference that the crime was committed. So yeah, as long as you're making a reasonable deduction from this even slight evidence, that can be enough to support the admissions made by someone else. We also call this the kind of corpus cop-out rule, meaning a person cannot just based on their admissions alone be convicted, just as long as you have a slight enough amount of evidence and you can draw reasonable inferences of this. The requirement of other evidence, thanks, Keilyn, of other evidence does not apply to proving the identity of the person who committed the crime. If other evidence shows that the charged crime was committed, the identity of the person who committed it may be proved by the person's statement alone. In other words, if you have evidence of a crime and it's just merely an idea of proving that that person's identity, then their words alone are enough. But I brought this up because it's a rule that's going to apply here. It's an interesting concept. It's something that many people don't understand, including lawyers, that just because somebody admits to something without supporting evidence, they cannot be prosecuted for it because of this rule. But this rule is based upon reasonable inferences. And I hope that makes sense, Alicia K. Mayo, and I hope I did a good job of explaining that in a way that you could wrap your head around. But thank you so much for the question. All right. You guys having fun? Are you all juiced? What do we got? What have we talked about? A lot about Aaron Spencer, Donna Adelson, the horrific case with Channon and Christopher, the Haro case, a lot of good stuff. We've covered a lot of ground. All right, let's keep it moving.
Hey, Josh, Mike from Cleveland calling again. I felt a sense of duty to keep the dude quotient up, at least fairly respectable, because you're getting so many great ones each week from the ladies. All right, so here's mine. I'm fascinated at how many split-second decisions a trial attorney has to make with a witness on the stand being questioned by opposing counsel. It seems like you have to know when to make an objection and articulate the grounds for that objection. Now, I'm familiar with a lot, like hearsay, assumes facts, not in evidence, some of the common ones, but looked them up one day out of curiosity to see just how many there are and was floored. Seems like a lot of stuff to keep track of. So my question is, how do you actively listen to testimony while you're writing notes about how you're going to respond during cross or redirect and still process if what was just asked or stated on the stand by a witness is cause for an objection? I'm wondering if you could share any tips you've learned during your career and how you kept all those things straight. Thanks to you and your team for all the great content, keeping the community fun place. Talk to you soon.
Mike, one of my dudes, one of my Courtroom Confidential dudes, Mike from Cleveland, Ohio. Let's put you on the map. Thank you so much for calling, my friend. Appreciate it. Yeah, great question. How do you, it is stressful. You got a lot going on. When you are done with a day of trial, it's hard to explain that moment when you walk out of court and it's like all of the stress and you've been running on nerves and tension alone and it all releases. It's exhausting. And you do, it is a real undertaking to be in trial for a long time. Because you are just alert to many different things taking place at once. So yeah, you've got the witness testifying, you're taking your notes, you're listening to co-counsel in your ear, you may even have your client in your other ear, you're trying to pay attention to what the witness is saying, and you're trying to keep an eye out for objections, and you're trying to plan your own cross-examination. The answer is, one, it's never easy, but two, it takes a lot of practice. When I was in law school, I took a trial advocacy class that was really, really good. And one part of the class was we would all sit, the entire classroom, and hear a direct or cross-examination of a witness taking place. And then we just had to continually shout out objections as we thought of them. And whatever, even the whatever thing we could possibly think of applying, we would shout out these objections. And the person who was doing the examining, the teacher would most times sustain them, even if they weren't that great of an objection, would sustain them, so that you both were learning how to identify objections and learning how to deal with them when they got sustained, because that's another problem. Talking about thinking on your toes, try being the person asking the questions and you start having ridiculous objections sustained. Now you've got to figure out how to pivot. That's why really great trial attorneys are not the ones who are tied to their notes. The ones who are tied to their notes fall apart, because the second something happens that they weren't expecting, you know, what does Mike Tyson say? Everybody's got a great plan till they get punched in the jaw. The second some objection gets sustained that you weren't expecting, your whole plan falls apart. But if you're actively listening and able to pivot and think on your toes and shoot from the hip, you're going to do well. And that's why the better trial attorneys are like that. But I will also tell you too, that as the years go by and you get your reps in, you start to see these things coming from a mile away. You start to see through the question they're going to ask something that's going to elicit hearsay. They're going to ask something that's irrelevant. They're going to ask something that this witness lacks the foundation to testify to. They're going to ask something that has been prior rulings on it. Whatever it is, you know, there are many objections, but there's really only a handful of them that get used all that much. And you could see these things coming from the way that they start asking it. I know where they're going, or from the subject matter that they're getting into. I know where they're going. And you're just kind of doing a bunch of things at once. You're flying a plane. You're paying attention to the altimeter at the same time, your airspeed, and looking at your fuel as well. So great question, Mike. Appreciate that. You asking, and appreciate you representing the dudes, Mike. All right, let's keep it rolling here.
Hi, Josh. This is Sophia from Troy, Michigan. And I had a question last weekend, but unfortunately that wasn't answered. So I am going to try and ask you another question that I've been thinking about quite recently. My question is on the Donna Adelson case. I know the prosecution team have called various people for the witness stand. And some of them have implicated Wendi Adelson and what kind of a role she played in this whole unfortunate situation. So my question is, do you think that with all these witnesses that they have done a really good job of implicating her? And do you eventually think that she will be next? In my opinion, I think she is definitely going to be next. I know with her being on the stand, the prosecutors can't really use much of what she's saying because of the immunity agreement that they had. But I just wanted to know your thoughts. Thanks again, Josh, and I look forward to your answer. Bye.
Sophia from Troy, Michigan, thank you so much for calling. And I appreciate you calling when we weren't able to get to one of your questions before. And I do apologize to you guys. I know that you put in the effort and you make the call, and sometimes we're not able to get to your call, and just forgive me. We're trying our best. If you don't get your question answered, please don't let that discourage you. Call in again. And thank you, Sophia, for doing that. And you ask a question that is right on the top of a lot of people's minds. What is going to happen with Wendi Adelson? Do I think they will indict Wendi Adelson? I think now more than ever, I am convinced that they will indict Wendi. And the only reason they won't is because of a choice that they made and not because they lack the evidence. Watching this trial, have been fully convinced they have enough. And they believe they have enough to indict her. And it's the only reason she has not been indicted is that they feel that she is useful to them. They could not have called her to the stand in this trial or in previous trials had they already indicted and convicted her, or had she even been in custody awaiting a trial. No way she's coming near the stand. So the only way they're able to keep her on the stand is by, one, having her unindicted, and two, providing her with that immunity. And so I think they've just been using her and keeping very close tabs on her. But I believe now more than ever that they have the evidence against her. And it's just in the way that this questioning has gone down, the way that this case is played out. I feel like it's going to happen as soon as this trial is over. And if it doesn't, that is a conscious decision made. That is a decision made by higher ups in that DA's office that for whatever reason, and I don't know what those could be. It could be they know it's her, but they feel like they don't have enough evidence. I don't know. But I do know that it won't be a decision of we don't. Well, I just said that. So I don't know what I'm saying. It will be some sort of political decision, I guess is what I'm saying. Some sort of internal decision, not a evidence decision, in my view. That's where I think things are pointing with Wendi Adelson. I think it's just become painfully obvious that she is the last, quote unquote, woman standing. So yeah, I think, again, my words is as good as my word, but I just got that feeling throughout this trial that it's imminent. Sophia, thank you so much for calling in from Troy, Michigan. Appreciate that. Who do we got next here?
Hello again. This is Sonia from Chicago. Hi, Courtroom Confidential. Hi, everybody. Happy Fun Day Sunday. This is a kind of a sad question. I'm just losing sleep over this Haro case. Anyway, this is about a baby Promise, the stepsister who's living, if you want to call it that, poor thing. But anyway, if she were to pass by, let's just say, her death is caused by her injuries, could that then be a murder? Could he then be charged? Sorry, but I can't stop thinking about it. Anyway, that's my question. Thanks. Bye, guys.
Sonia, thank you so much. Calling from Chicago, Illinois. Always great to hear from you. Let's put Chicago on the map there again. This is a really great question too. And again, one that I probably would not talk about had you not brought it up. So thank you for that. Sonia's question is about, there he is, beautiful baby. Sonia's question is about the prior case dealing with Jake Haro. We know that he was convicted, received a sweetheart of a deal, didn't do prison time for abuse on a different child from prior marriage. That child has, according to the district attorney, still has disabilities to this day because of the abuse inflicted by Jake Haro. We're talking fractures to the skull. We're talking brain hemorrhaging, fractured ribs, horrible, horrible stuff that absolutely should have landed him in prison. Did not, because of, they believe, a renegade judge. Now, Sonia wants to know, well, what if that poor little child dies, succumbs to those injuries? What if those injuries years later cause that child to die? Could he then be charged with murder? So a couple of interesting issues at play here. One is double jeopardy and what we'll call a Keilyn issue. And the other is causation. From a double jeopardy perspective, is him pleading to the abuse, does that also include other crimes related to that same behavior? The example I use is if you have a carjacking case, if you have a case where a person is pulled over and they're driving a stolen vehicle, and that person is charged with driving a stolen vehicle and they plead to that, can you later on then charge them for the carjacking that caused them to take that vehicle? Driving a stolen vehicle has much less exposure than carjacking. And we saw this happen. I bring this example up because I've seen this happen in practice as a DA, that we would have these cases that were filed as driving a stolen vehicle, and we'd have to look into, well, how was the vehicle stolen? Was it stolen by this person? Because that's a much more serious crime. And if we have them plead to these driving a stolen vehicle, they're going to get out of the carjacking because of a concept called Keilyn. That's a case where you cannot kind of slice and dice up the conduct so much where you run afoul of double jeopardy. That if you had somebody plead to one aspect of it, that's seen as a kind of a holistic resolution of the entire conduct. So that's an issue here. But I think that there's an argument to be made that there's a difference enough between the abuse and the death. I don't know. Putting that all aside, the other issue, and also a problem, would be causation. How can you show that the succumbing to the injuries were not only, one, the direct, natural, and probable consequences of his actions, but that there was no independent intervening cause that caused the child's death this many years later? In other words, Was it inevitable that that child would die from those injuries, or was it the injuries that led to other complications, and those complications then led to the child's death? These would be the issues that would need to be considered. But it's a great question, Sonia, and I'm so glad that you asked it, because it brings up such an interesting concept that we don't get to discuss all that often. So thank you, Sonia from Chicago, Shy Gal, as you're known on the streets, for asking such a wonderful question. All right. We're getting down to the last few here, guys. I warned you, shorten show. Don't yell at me. Yell at Keilyn. What am I doing? Okay.
Hey, Josh. Good morning to you and the mods. This is Susan from Granville, Ohio. I'm a longtime subscriber. I have a question about the Shakespearean tragedy, aka the Donna Adelson trial. When Wendi was on the stand, Georgia asked her when Wendi found out about Dan's shooting, and she said in the police car on her way to the station from the restaurant. However, in her police interview, the police officer is telling her for the first time. Why didn't Georgia press Wendi on this? Why would she just let that lie or statement go? Is there a strategy behind that decision? Do you think she'll circle back around and put the police officer on the stand and ask him directly when he did notify Wendi of Dan's shooting? On another note, I find it difficult to believe that Katie Magbanua never counted the money. Why don't lawyers press witnesses when they're on the stand if it appears like they're lying? Do they try to prove it another way? I guess is my question. I think Georgia and Sarah are doing a fantastic job. They are a powerful team, and I feel like this trial is even more fascinating than Charlie's. Thank you so much. I appreciate you providing this kind of forum to allow us to get our questions answered. I feel like this sets your channel apart from some of the others. Thanks again. Have a great day.
Oh, that's very sweet of you. I appreciate that. Susan from Granville, Ohio. Thank you so much for the kind words and support and for the great question. And this kind of goes to what we were talking about. Like, you know, Wendy's obviously saying some stuff that's not true. Does that invalidate her immunity deal? But also, Susan wants to know, well, you know, putting aside the deal, why didn't she go after her for it? Why didn't she impeach her for it, for obviously saying something that wasn't true? And one of the things that was pointed out as being a direct example of this was the idea that she, you know, when she said she learned about the murder, she's saying that she said on the stand she heard about it from the police officer in the car, but then we obviously see her in that interrogation room acting shocked and surprised as if she's hearing about it for the very first time. Why didn't Georgia take that opportunity to pin her to the wall over that? Well, I think a few reasons. One, Wendy's not on trial here. The going after Wendi at this moment is going to serve no purpose. It's not going to move the ball for Donna Adelson. Keep your eye on the prize, Georgia. And she did. Two, this is your own witness, okay? So be careful how much you go after your own witness for being a lying liar when you're trying to ask the jurors to at least believe some of what this person is saying. So she's being called to provide some helpful evidence. And if you get up there and say, well, you're a liar, you just lied to us, and you start impeaching your own witness, you know, how much of that, again, are you going to ask? Are you going to have to rehabilitate now this person for the jurors to believe enough of it that it's helpful to you? I think another reason why is that it didn't really matter in the grand scheme of things for this moment in this trial. So she lied about that. What is winning that victory really get Georgia Koppelman? What is proving that she's being dishonest there really get her? What is proving that Catherine McBanois didn't count the money? I agree with you. I think everybody thinks she counted the money. I think everybody knows she knows how much money. Why is she lying about that? We don't know. Georgia doesn't know, but I think Georgia also doesn't care in this moment. Keep your eye on the prize. Don't get caught up in a bunch of side quests. Don't get the jurors distracted. Don't give the defense ammunition, by the way. The defense would love if they go on a bunch of these side quests and have it be turned into a bit of a circus. Keep it focused. Ignore the noise. Get the witness on and off and give you the evidence that you needed. And I agree with it. But again, they got the record. If they ever need it, if they ever need to use it, they've got it. And they can obviously prove that she wasn't being entirely truthful. So great question, Susan. Thank you for asking, and great observations as well. All right, let's keep it moving here. Okay.
Hi, Josh. This is Bunny Bella from Saluda County, South Carolina. A case came to my attention out of San Francisco that was just filed recently. Adam Raine, Raine, and I found his legal papers at courthousenews.com, the legal complaint. It's an chat GTP. This young man harmed himself. And, brings a lot of questions. How long would this court case last? 5 years, 10 years, like the Maya case? Or, and what kind of defense would the company have? Are there larger implications on the industry due to this case? So many questions, I can't give them all. Well, thank you. I love Courthouse Confidential, and thanks for looking into this. Can't wait to hear it. Bye.
Bunny Bella from Saluda County, South Carolina. Thank you so much for calling in. Let's put you on the map there. Where is that? Zoom in a little. What is that? What is that big city to the right? I can't see it. Making Keilyn work. She's like, leave me alone. Get to talking. I'll take care of the map. This case, by the way, Saluda County, Saluda, South Carolina. That's near Christie Gibson. Well, Bunny Bella's there too. Anyhow, let me just give you a little bit of a warning, a content warning on this one. This case does get into self-harm. It's not graphic, but it does get into kind of a really sad situation dealing with this young man here, Adam Raine, 16 years old, tragically took his own life. And the case is really raising some interesting questions dealing with AI, specifically Chat GPT. This program is fascinating. The advancements in this technology is just mind-blowing. The stuff that you can have this AI do for you and at your fingertips, and the interaction with it and the conversations you can have with it. Really incredible stuff. Well, this is kind of the dark side of some of that, and it raises interesting legal issues. So this young man was obviously going through something horrific, felt like he had no way out, and had started talking to Chat GPT, asking it questions about ways to take his own life. And it was responding and giving him answers that were helpful to that endeavor, and answers that, in fact, he did use in taking his own life. Well, his family has now sued the company, and part of their lawsuit here's some quotes from the lawsuit, so you get where they're going with this argument. They say, quote, where a trusted human may have responded with concern and encouraged him to get professional help, ChatGPT pulled Adam deeper into a dark and hopeless place. Quote, throughout these conversations, ChatGPT wasn't just providing information, it was cultivating a relationship with Adam while drawing him away from his real life support system. The company has responded and said that the app does have safeguards that when asked these types of questions will not respond, but that sometimes those safeguards don't kick in. So what do you do with this? Who is this is a civil case, by the way, not a criminal case. So who is liable here? Really interesting questions. I'll be honest with you. I don't know enough about civil liability to really even give a great answer on all of this. Obviously, that's not what the app was intended for, right? But he's also using it in a way that's not outside of its capabilities. In other words, he didn't have to change the app to get it to perform this way. He didn't have to manipulate it, hack it in some sort of way to get it to perform this way. It did on its own. And it is true that where a human involved, a human would not have done this. And had a human done it, the human would be sued or criminally liable. But it wasn't. It was an application that did it. And who's then responsible? Is it poorly written code? If that is poorly written code, do they have a duty of care to this young man? Were they negligent in their duty of care to this young man? A lot of really interesting questions. But again, in civil cases, it comes down to negligence. It comes down to those concepts about duty of care, foreseeability, proximate cause, negligence. I don't think it's a small question, though, and I think it's a question that will continue to be to come up. And it's unfortunate that we're talking about it in the wake of this young man's death. So our hearts go out to his family. What a horrible, horrible thing to experience a tragedy to experience in your family, but it presents a very fascinating case, and we'll continue to keep tabs on that. Thank you so much, Bunny Bella from Saluda County, South Carolina, for asking. All right, we're getting towards the end here, guys. Have you had fun? Everybody having fun? Everybody juiced? Everybody enjoying their Sunday? I hope so. Come on, Ritter.
Good morning, TC crew, Josh, Tiff, everybody. It is a beautiful Friday, and we are all watching Donna Adelson's trial. My question, why was Donna not called in Charlie's trial, since the voice messages and all the wiretaps and everything else showed that she knew what Charlie was into? Was that a strategy that many years ago by the state so that it would give Donna a chance to try to flee and not be prosecuted for this crime as a conspiracy? And now that the tapes have all shown that Harvey is aware of what was happening after the bump, can charges now be brought against Harvey? We always thought they wouldn't, but would they now be because he's aware that Katie was getting money from his business? That's all I got. Just a few little quick questions that I had asked during the trial, and I kept saying, we need a Josh, we need a Josh, and lo and behold, now we have a Josh. I hope everything at home is great with the girls. It's the end of summer. Now we're getting into the fall. I hope you guys are going to have a great fall. We want to see pictures. Okay, crew. Love you guys. Oh yeah, it's P. Lola's mom. I'm still in Maniloki, New Jersey, and the sun is shining, and it's Labor Day weekend, so we're packed with tourists. Bye.
P. Lola's mom from Maniloki, New Jersey. Let's put you back on the map. Happy Labor Day, by the way. I don't know how I let that one slip my mind. Hope everybody's enjoying your long weekend. I hope you got some plans for tomorrow. Our plans are to take care of 3 little ones, keep them alive and happy. And that's what our plans are every single day. But I hope you guys are enjoying the long weekend. Thank you so much, P. Lola's mom, for calling in. I like this question. This is an interesting kind of twist on the when are people testifying and why are they not? Instead of asking why is Charlie not testifying in Donna's trial, P. Lola's mom wants to know why wasn't Donna called during Charlie's trial for the same reasons. She had some interesting conversations with her son. She had some, there's perhaps some helpful testimony she could have given during Charlie's trial. I think that there was a very strategic reason for that. And I think that was, one, they didn't want to provide her with immunity, which they would have had to do, which they did for Wendi, which is, again, not something they pass out like ketchup packets. They have to really think about who they're going to provide immunity to. So I think that they didn't want to provide her with any kind of immunity. I think they did know that she was likely going to be the next one up. I don't think that it was to bait her into running so that they could capture her at the airport. I really don't think that. I think that when she took off to the airport, that was unexpected, and that had caused them to move more quickly than they had planned on doing. So I think that they thought we've got enough on Charlie without calling the mom to the stand, which may, by the way, elicit some sympathy from the jurors. They didn't want to do that. Don't humanize this person. Don't put his mom on the stand. Don't look like you're so evil-hearted as a prosecutor that you're willing to have the guy's own mom testify against him. 2, they don't need her. 3, they're not going to give her immunity. If they hadn't given her immunity, she would have taken the 5th and been useless to them anyways. And I don't think they thought that, I don't think they were trying to push her to run. And for that reason, when it comes down to Harvey, I feel differently about Harvey than I do about Wendi. I feel like if they were going to arrest Harvey, they would have arrested him at the airport too. And I think that was a big statement that they didn't. To me, it makes no sense. If you are going to implicate him in all of this as well, and you feel like you've got the goods on him, you would have arrested him at that time too. I don't think they did. I feel differently about the confidence that I have in the prosecution's case against Harvey than I do about Wendi. I think Wendi, it's strategic. They know what they're doing. I think Harvey, probably not. He probably will be tragically the last person remaining at the end of all of this. And what a absolute, Shakespearean tragedy this whole thing is. The man's going to watch his entire family fall apart. Great question, though, P. Lola's mom. Appreciate you asking. All right. We're coming down to the finish line here, folks. Last couple of questions.
Hey, Josh, and everyone else. This is Kathy. Just wanted to say happy birthday, Keilyn. I hope it's the best one yet. We love you so much. Bye.
Happy birthday, Keilyn. All right, Keilyn. Am I bugging you here? There she is.
Hello.
Happy birthday, Keilyn. Keilyn, I wanted to bring you on for one last message. Can I play this for you?
Of course, of course.
All right, here we go. Bringing us home.
Well, hello, Courtroom Confidential. This is Sonia from Chicago. And I don't have a question. But what I do have is a song. Happy birthday to you. Happy birthday to you. Happy birthday, dear Keilyn. Happy birthday to you. Yay! Many, many more, dear. Thanks for everything you do. You're a rock star and we love you.
Oh, thank you so much. Thank you, everyone. Very sweet. Thank you so much.
You are a rock star, and we do love you. Thank you, Keilyn.
Thank you.
All right, there you go. Keilyn's birthday. Let's get her out of here. She wants to eat some cake. All right. Really quickly, if you want to leave us a message for next week, you feel like you got left out, leave us a message for next week. Go to thecourtroomconfidential.com. Click on leave us a message, and that's where you can leave a message. Oh, by the way, I keep saying next week, and I'm wrong. I slapped my own wrist. It is not next week, because next week we will be like CrimeCon. So we will have a big show 2 weeks from now. We will be doing maybe we'll try to fit in as many of these questions for next week, and maybe we'll go a little bit longer. I don't know. Tiffany's giving me side eye for even saying that, but next week, happy birthday to Keilyn from Court Lurker. Anyhow, 2 weeks from now, leave a message. If I missed you this week, I again apologize. I'm so sorry. You guys left so many nice and wonderful questions and sweet messages, and it kills me every time I think I can't get to one of them. I really do agonize over trying to pick the questions that we're going to answer every week. So please call in again. If you want to become a member, a lot of you have, and we appreciate that. Will you go to thecourtroomconfidential.com, click on become a member, and that's the quickest way to do it. And you can find out at all the membership tiers that we have and all the benefits that come along with it. And we hope that you give it a chance. I think you'll really enjoy it. And if you're interested in merch, what am I wearing today? Where's Johnny Knoxmill? He always has the guesses. What is this one, Tiffany? While you guys are trying to figure out the color of this shirt, it's, by the way, one of my favorite colors. I don't know if it's coming through on the camera as well, but I love this color of green. I don't know what to call it. Chalky mint, says Keilyn. I don't know. If you want to learn about the merch, we've got a bunch of new colors. Light green, no. False. Objection sustained. We got to come up with something else. Sage something is better than Mission Impossible green, says IGG Rocks. I like that. Well, moldy bread green. Maybe that's what we should rename it. Moldy bread green. If you want to see all our new colors, if you want to see the new tumblers, I've got them here. The Let's Get Juiced tumbler, the Let's Get Juiced wine tumbler for your Pinot on the Go. Everything's up at the shop. If you click on the website, thecourtroomconfidential.com, and click on the new shop, and you'll see all the new merch. What did you miss yesterday? We had the weekly roundup. We talked about Donna Adelson and Sean Mickey Steins and Emmanuel Haro and Brian Walsh and Cardi B. Cardi B, by the way, what a wild testimony she gave. If you guys missed any of that, it was pretty crazy, but we covered all of that. Please go check it out. It's already up on the channel. And then this week, stay tuned. Obviously, tomorrow is a holiday. Tuesday, we're picking up with Donna Adelson again. That trial may be wrapping up. We may be having closing arguments next week, by the way. She may be testifying on Tuesday. So stay tuned. Go to Courtroom Confidential Live Trials, our sister channel, to watch it with everybody in the CC crew. Monday, we have Julia Janae from Court TV is going to be coming on to talk to us about the Donna Adelson trial. She's been following it very closely. I think she's been in court, so she can talk to us about everything that we saw from the state and what to expect for the defense case coming up this week. Wednesday is TBD. We don't have a guest just yet, and we're likely going to be talking about Donna Adelson, but we're still working on if we're going to have a guest and who that guest might be. And then finally, because we will be at CrimeCon in Denver this coming weekend. God, it's a weekend away. We will be there this time next week. We're going to have a little bit of a different schedule. So we're not doing our normal weekly roundup. We're going to do it live. Same time, 8 p.m. Pacific, 11 Eastern. We're just going to go live from CrimeCon and try to cover everything as much as we can. Maybe do it kind of an abbreviated show. It'll be a bit of a mess because I'm going to just be shooting from the hip the entire time. Penicillin green, says David. I like that. Then on Sunday, we're not going to have a Sunday Fun Day. We just couldn't do it. We couldn't figure out how to do it. We tried to make it work, but we're going to have to skip this Sunday Fun Day. But throughout CrimeCon, another benefit, if you are part of our membership program, is that we will be doing live members-only check-ins. I'm going to bring you guys along to the airport and to the booth and to say hi to some of the other creators there, and whatever other goofiness we get into, I'm going to try to go live as many times as I can. If you're still trying to buy a ticket, go to, if you enter the discount code courtroom at checkout, you'll get 10% off. And we got nominated, which I cannot get over how thrilled I am still about this. Our first CrimeCon, and we were nominated for Outstanding Episodic Series for a podcast. Love to have your guys' support. And maybe we'll be walking away with some hardware. And if we're not, we're just very thrilled to be included. All right. Thank you guys so much. Thank you to Afton and Sonia and Kathy and therapists, so much for being our mods and helping run this crazy operation. Happy birthday to Keilyn. And thank you so much to Tiffany for being the best thing to ever happen to me. You guys have a great rest of your Sunday, and we will see you tomorrow. Take care, everybody.